Good afternoon, ladies and gentlemen. Welcome to the Institute of International Relations. My name is Veronika Bílková, and I'm a research fellow here at the Institute and also the coordinator of the Center for International Law, one of the two centers established at this institute alongside the Center for European Security. The purpose of this afternoon's event is twofold. First of all, we will have a lecture by our dear guest, Professor Anne Peters, the director of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, whom I warmly welcome in Prague. I'm really happy to have her here, and whom I will introduce in more details in a minute. The lecture and then the discussion will be followed by the second part of today's afternoon program, and that will be the official launch or the official inauguration of the new Center for International Law established here at the Institute. And obviously, you are all welcome to attend the two parts of this afternoon, so they are both open to public. Now let me introduce our today's guest, Professor Anne Peters, and it's really not only an honor but also a very personal pleasure to have her here, because I have tried to arrange a meeting and public lecture of Professor Peters for quite some time, and I'm very happy that finally I have succeeded. So Professor Peters is definitely one of the best known and most innovative and original international law scholars in the world today. She is, as I already mentioned, the director of the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany, which again is one of the best known institutes of its type, not only in Europe, but generally in the world. She's also a professor of international law at the University of Basel in Switzerland and also at the Universities of Berlin and Heidelberg in Germany. In addition to her background in law, she also has a background in modern languages, more specifically Spanish and Greek. But do not worry, she will speak in English today, not in Greek. That could be also interesting, but probably not many of us would be able to follow. From 2010 to 2012, she was the president of the European Society of International Law. And then from 2011 to 2015, she was a dear colleague of mine at the Venice Commission of the Council of Europe. And we worked together on a couple of opinions, including one on the legal status of Crimea, which again is a very interesting topic, but not one that she will cover today. Nowadays, since 2013, she has been the member of the Council for International Law of the German Federal Foreign Office. Professor Peters has published extensively in the area of international law, touching upon various aspects of this complicated problematic. More specifically, she has dealt with such topics as the constitutionalization of international law, the position of individuals within international law, human rights law, or global animal law, which again sounds very interesting. But today, she will speak about a different topic. She will speak about the use of force against the Islamic State, and I hope that you have all picked up a copy of the syllabus of her presentation, which was available at the entrance. I'm very happy that she has agreed to speak about this particular topic for three reasons. First, this issue is unfortunately still very topical. Secondly, it's very interesting from the international point of view. It poses various challenges to international law that she will describe. And finally, it is also relevant for the work of our new center, because the Center for International Law of the IIR has just started working on its first research project, and the topic of this research project is exactly the use of force against the Islamic State. Without any further ado, I will give the floor to Professor Peters, who will speak for about 45 minutes. Then we will have the discussion, and then the second part of the event, that means the launch and the cocktail, will start. Professor Peters, you have the floor.
Yeah, thank you very much, Professor Bílková. I'm very happy to be here, and I think I'm very lucky with the weather and the hospitality I've been enjoying here. The last time I was in Prague, the so far only time was when I was a student. That was, I'm ashamed to say, before the fall of the war. So much has changed since then. As Professor Bilkova said, I have gotten to know her mostly through the Venice Commission. She is a member of the Commission by the Council of Europe for the Democracy Through the Rule of Law, the so-called Venice Commission, where she plays a very important part and is a very recognized expert member of that commission. That's how we got to know each other, besides academic conferences and so on. So, my topic is self-defense against the Islamic State. Is international law in the process of changing? Question mark. First of all, I would like to remind you of the facts, very briefly, and the legal claims which have been made. As you know, since the fall of 2014, the United States and a number of Arab states began to strike positions of the Islamic State, as well as posts of the so-called Khorasan group, which is considered to be an offshoot of Al-Qaeda, both on the territory of Iraq and in Syria. And these military strikes have continued on a regular basis in the course of 2015 into 2016. Currently, 63 states out of 192 or 193 states in the world consider themselves as a member of the global coalition against the Islamic State. Russia is not a member of the global coalition, but operates independently in Syria upon invitation of the Syrian government against the Islamic State. In Iraq, strikes are conducted besides by the United States by 8 other states, and I have some numbers about the quantity of the military strikes. More than 10,000 military strikes have been conducted by the United States. Most of them, far the majority, by the United States themselves, 7,800 by the United States, and the rest by the other active members of the coalition. But the other members undertook on the territory of Syria so far only about 200 military strikes. So a very small percentage of military activity in Syria is conducted by other states. So one could say that still 53 states who call themselves to be part of the global coalition are still reluctant to operate really in Syria. They say that they want to form part of the coalition, but they don't perform military strikes. And on the other hand, 182 states of the world do not participate in this military activity. That's just to give you a rough overview, because the practice of states is, of course, important to identify what the state of the law is. The operations of the United States and its allies have been accompanied by legal claims, and I think we could roughly say that there have been 3 distinct phases. It started in September 2014, and the military action was still quite moderate. Then a second phase with intensification in the course of 2015. And third, the very important event were the Paris attacks of 13th November 2015, which also led to a change of attitude of France. So these attacks inaugurated a third phase, and in this third phase belongs also the Security Council resolution number 2249, which was adopted on 20th November 2015. In all 3 phases, legal claims have been forwarded, but they are quite muddled, and they have also changed through time. States conducting the military action and also other states who have commented on that action rely on various grounds as a legal justification for their action. You know that we have a general prohibition on the use of force under the UN Charter, so every use of military force needs a special justification. The first justification which has been mentioned is individual self-defense against the Islamic State directly. The second justification is invitation by Iraq and collective self-defense of Iraq against the Islamic State. The third justification might be the Security Council Resolution 2249. You know that upon Security Council authorization, military activity is allowed. So the 2 basic allowances are self-defense on the one hand, Security Council authorization on the other hand. But both these justifications do not fully fit in the case of military action against IS, and I'll look at that now in detail. So let's look at the handout, where I mentioned the claims which have been made. I hope everybody has a handout, because it's easier to follow, I think, if we have it. The first claim is individual self-defense directly against the IS and or directly against the group Khorasan, which is also a terrorist group. I mentioned on the handout the states which have relied explicitly on individual self-defense. First of all, the United States. On 23rd September 2014, the United Nations Secretary General received a letter from the Ambassador of the United States at the UN, Ms. Samantha Powers, where she justified the US military action in Syria. I quote this letter, or the most important parts of the letter. First of all, she writes, "States must be able to defend themselves in accordance with the inherent right of individual and collective self-defense as reflected in Article 51 of the UN Charter. When, as the case is here, the government of the state where the threat is located is unwilling or unable to prevent the use of its territory for such attacks." End of quote. It's very important that the United States here mentions unwilling or unable as a key word. In the letter, the United States then apply this principle to the Syrian situation and say, the Syrian regime has shown that it cannot and will not confront these safe havens, that's another key word, safe havens, effectively itself. Then, in the letter, there's the subsumption, one could say. Accordingly, says Samantha Powers, the United States has initiated necessary and proportionate military action in Syria in order to eliminate the ongoing ISIL, Islamic State, threat to Iraq. So first of all, protection of Iraq, collective self-defense. But then the United States also mentioned individual self-defense concerning the Al-Qaeda offshoot Khorasan. That's strange. One could say that the US claims already in September 2014 that it is itself threatened by the activity of the Khorasan. Nobody ever heard of the Khorasan before that. I didn't. So Khorasan threatens directly the United States. Important is also that the United States explicitly say, we did not request the regime's permission. Of course, the US does not want to collaborate with Assad and wants to make clear that there is no coordination. We did not coordinate our action with the Syrian government. That's what the United States say. I don't know what they really do, but that's what they say. The United Kingdom also relies on collective and also on individual self-defense. Specifically, they did, the United Kingdom performed a targeted killing, one could say, in August 2015. And killed 2 individuals, in which they say belong to the Islamic State. Turkey also claims individual self-defense. I mentioned that also under the heading individual self-defense, and Turkey also uses the term unable and unwilling and says that Syria is neither capable nor willing to prevent the threats emanating from its territory. France began with the airstrikes in Syria even before the Paris attacks, already in September 2015. Some also say that the Paris attacks were the reaction to the strikes, right? So it started in September 2015, and France also wrote a letter to the Security Council and spoke of a menace, threat to the security of France, already in September. The term menace, threat, is not the term armed attack. I think that's on purpose, but still, somehow they rely on individual self-defense and explicitly again say that after they have been attacked. The Paris attacks of November did change the legal discourse. The French representative Delattre in the Security Council said that now our action can also be characterized as individual self-defense in accordance with the UN Charter. let's move to the second type of justification, collective self-defense of Iraq, meaning that states protect Iraq, and this is allowed also under the UN Charter, under Article 51. And indeed, Iraq had written a letter on 20 September, so that was before the US started, so that was the starting point actually, that Iraq says it is grateful for military assistance it is receiving, and Iraq also notifies to the United Nations that ISIL, Islamic State, has established a safe haven outside the Iraq's border in Syria that pose a direct threat to the security of our people. That's what Iraq says, and has therefore, on that basis, because it feels directly threatened by the Islamic State, has asked for help, and it has received help from the United States and others. I noted on the sheet, on the handout, which other states also point and argue that they are participating in collective self-defense in favor of Iraq. That's the United States, United Kingdom, Australia, France already before the attacks, and Canada as the latest state. Now the question is, of course, whether these claims are really covered by the law of self-defense under Article 51 of the UN Charter. And the main problem is here, of course, that the Islamic State is not a state in the sense of international law. It's a terrorist group. It is a disputed legal question whether self-defense in terms of Article 51 is allowed against an armed attack which does not emanate from a state, but from a non-state actor or terrorist group. The wording of Article 51 is open. If we read Article 51, we read the phrase, if an armed attack occurs against a member of the United Nations. The key word is armed attack, but it doesn't say armed attack by a state. Historically, we can presume that the drafters of the Charter in 1949 did not think of an armed attack which would not come from a state. It was clearly in an interstate paradigm. But the wording does not prohibit that. It doesn't mention states, so the wording would allow to interpret the provision more broadly. One could say that the purpose of Article 51 of the allowance of self-defense requires that states are allowed to take some action, because otherwise there would be a gap in the protection of victim states. And you all know that since 9/11, 2001, since the Al-Qaeda attacks on the Twin Towers in New York, there has been a lot of talk about new threats, and clearly there is a perception and also as a fact that terrorist threats and terrorist large-scale attacks even are happening. On the other hand, the problem is, of course, with every broad reading of the allowance of self-defense, there is a danger of escalation. Therefore, the International Court of Justice, in its case law, has been reluctant to recognize self-defense against non-state armed attacks. But even that case law is ambiguous, and there are different interpretations. I mentioned the most important judgments and advisory opinions on the handout. The first in time was the judgment Oil Platforms of 2003. This judgment seems to confirm the requirement of a state attack. This is between the United States and Iran at the time. Although the court doesn't fully say so, but it says in en passant, speaks of an armed attack by Iran, so it somehow presupposes that it must be an attack by Iran and not by anybody else. In the Wall opinion concerning the building of the Israeli wall, the court also seems to require an armed attack by a state, because Israel relies, as a justification to build the wall, it relied on armed attack by terrorist groups. And here the court said, well, self-defense, the Charter, that's what the court says, recognizes self-defense in the case of an armed attack by one state against another state. But Israel didn't, the statement, if you read the whole context, which I won't do now here, the statement is a little bit strange, and it's not 100% clear what the court really means in this case. And the last case is Congo versus Uganda of 2005, and here the ICJ explicitly left this question, which was at that time, this was after 9/11, the question was of course already highly controversial, whether an armed attack could emanate also from a non-state actor, and the court missed the opportunity to make a clear statement, but explicitly left it open in a famous paragraph, and it said, the court has no need to respond to the question whether and under what conditions contemporary international law provides for a right of self-defense against large-scale attacks by irregular forces. So the key word here is large-scale attacks by irregular forces. The term large-scale attacks is important, and I'll come back to that later. In that, that judgment had been accompanied by two important dissenting opinions of judges which said that large-scale attacks by non-state groups should count as an armed attack. And indeed, I would say that there is a clearly prevailing trend in scholarship since 9/11-2001, since the New York attacks, that self-defense should be allowed against non-state armed attacks, but with some qualifications. Let's look at the policy arguments for and against allowing self-defense against non-state actors, which would then also allow self-defense against IS, without asking for any link to a state. The main argument for allowing that is, of course, the fact of the new threats and the need to protect victim states effectively against new types of armed force used by terrorist groups. On the other hand, and I only put the counter arguments on my handout, there is the inevitable collateral damage. I put collateral damage in quotation marks, because any military action, also now against the IS in Syria, will of course inevitably affect Syria and its population and its infrastructure, because the Islamic State is not striking out of cyberspace. It inevitably has some territorial basis, so inevitably the state where it sits will be affected. It seems unfair to allow strikes against a group which will affect the state without drawing some link to that state. That's, I would say, a fairness argument. There is also the danger of abuse, and I think that this danger of abuse, of a broad reading of self-defense, has manifested itself to some extent in the case of Turkey, which uses the idea of collective self-defense gladly in order to combat the Kurdish party. That's, for me, a nice example for the danger of abuse. And of course, there's always the danger of escalation. The regime of the UN Charter and the entire international legal regime is based on a fundamental principle of a prohibition on the use of force. If we erode this principle, then that could be a recipe for escalation. So I would say that as an interim conclusion concerning the interests which are at stake, and this seems to me to be also the trend in scholarship, that a non-state armed attack does not and should not, without any qualification, count as an armed attack. So we might allow reactions, but not against every type of non-state armed attack. We need some qualifications, which then will trigger the right to self-defense. I put on the handout, I mentioned some prominent voices in this discussion. As I already said, there were two judges in the ICJ Congo versus Uganda case, the German judge Zimmer and the Dutch judge Koymans, which already in that case said that Article 51 allows an armed attack against, allows self-defense against large-scale attacks by irregulars. So these judges pointed to scale and effects, and that has some basis also in the law concerning armed attacks of states, because it has always been said, and it is clear, that a small military exercise, a mere border incident as the ICJ in the Nicaragua case said, would not count as an armed attack. An armed attack is something which has a higher threshold than use of force generally. It must be more serious, it must have a large scale and effect. Although we don't know how serious it must be, there is some qualitative threshold. And I think it makes perfect sense to say that this qualitative threshold, or a similar qualitative threshold, must also apply to non-state attacks. That's quite reasonable. So then I mentioned some other prominent voices. Daniel Bethlehem, he was the former legal advisor to the United Kingdom government. He published in the American Journal of International Law in 2012 principles concerning the self-defense against non-state actors, and already in 2012 he kind of presupposed that self-defense against non-state actors is admissible, only he said the question is not whether it is admissible, but only under which conditions. So that's his starting point. And he says, although he wrote in a private capacity as an academic, no longer being the legal advisor, he wrote that he drafted these principles on the basis of conversations with governments and so on. And importantly, he forwarded the pinprick theory, saying that if a terrorist attack, for example, if a group throws one bomb with, let's say, 3 casualties, and then 1 week later another bomb, and then some month later another, that could be a concerted pattern of continuing armed activity, which could in total amount to an armed attack. Because, also Bethlehem says that, we need a certain gravity so that the threshold will be passed, and Bethlehem says this can be reached through accumulation. But that's in reality not yet giving the answer, because the question is, when is the reaction allowed? Already at the first pinprick, presuming that there will be further pinpricks following, or what? So we have a problem here, we might discuss that. Another well-known standard are the Leiden policy recommendations of 2013, and then also the so-called Chatham House principles. These were written by a group of scholars, among them also one former, again, United Kingdom legal advisor, Elizabeth Wilmshurst. She was the deputy legal advisor to the UK in the times of the Iraq War of 2003, and she had the courage to resign because she said that the Iraq War was illegal. She resigned without giving that as a reason, she just resigned. And so I think she's a great role model for international lawyers. In any case, she is maybe the initiator of these so-called Chatham House principles, which were published in 2014, and they give a set of principles, and they also mention that the right of self-defense applies to attacks by non-state actors, and in such case the attack must be large-scale. I'm mentioning this question of scale and threshold, although for the case of the IS it's not directly relevant, because what the IS is doing is clearly large scale. I mean, we don't have that problem here. But we have that problem, with typical terrorist incidents. You could ask the question for Paris attacks, I would say, is also large scale with more than 100 victims. But if you have only 1 bomb or so, the question poses itself. So, it seems to me that the most important voices in the discourse, also among academics, accept that self-defense can be triggered by non-state armed attacks with some qualifications. And I only spoke about the scale now, but let's look at the other qualifications. The original idea was that attacks from irregular forces would have to be attributed to a state. So some kind of attribution, but as I said, now the discourse has moved away from that question of attribution and somehow looks for new types of links which might be looser. I think, as I said at the beginning, that for me it seems fair to require some type of link, because otherwise bombing a state which is not aware and can't do anything against terrorists seems patently unfair to me. But let's look at that more in detail. Historically, the first statement of the International Court of Justice was in the Nicaragua case, where the court also had to deal with irregular forces. And in that case, the court mentioned also the definition of aggression resolution of 1947. This resolution was adopted, as its name says, for defining what means aggression. That's actually something else than armed attack in the sense of 51, but nevertheless, always the court and also scholars rely on that resolution. Aggression, one could say, is something quite serious. So you could say that aggression is a serious use of military force, and it's somehow similar to armed attack, although aggression is actually the term which is used in Article 39 of the UN Charter and is needed to trigger activity by the Security Council under Chapter 7. So it's actually something else, but anyway, the court muddles it and everybody else does so too, so we'll do that too. And here, in that decision, the key word which was used was substantial involvement by the state. So the court says that a non-state armed attack can trigger self-defense if the state from which the attack emanates is substantially involved. That's also mentioned in that General Assembly resolution. That's a term which is also used there. The next idea was to apply the Articles on State Responsibility of the International Law Commission, on which concern wrongful acts, also to our question, because of course the armed attack is a wrongful act which triggers state responsibility, so it's perfectly logical to use these criteria of attribution, one could say. But on the other hand, the problem when self-defense is allowed is not the question whether to trigger state responsibility of Syria, but it's a different issue. So, but on the other hand, I think it makes sense, but the criteria of the Articles on State Responsibility are also quite narrow. I mentioned Article 8 and 9 of these articles, and they say that some activity, for example, the activity of the Islamic State, will be attributed to Syria if the Islamic State acts under the instructions or under the direction and control of Syria. This is clearly not the case here, because Syria has no control over the IS whatsoever. On the contrary, Syria tries to combat the IS, so it doesn't fit at all. And if we apply these articles, we would not come to an attribution to Syria. Also, the other provision which I mentioned, Article 9, which is doesn't fit either. So, if we apply these articles, we don't come to any conclusion, and we could even say that the articles don't fit anyway because we are dealing not with state responsibility but with a different question. Another strategy of argumentation which has been tried in scholarship, which I find quite interesting and sensible, is the question whether the armed attack of IS can be attributed to Syria because Syria is passive. So this is the question of legally relevant omission. Omission means legally relevant passivity, and as you know, also omissions can trigger responsibility. That's the case in criminal domestic law, but it's also the case in international law. So we could argue that Syria is responsible because it has omitted to prevent and combat and apprehend and prosecute ISIS. In legal terms, and I think everybody agrees that that's a general principle, not every passivity amounts to legally relevant omission, but only when there is a legal obligation to act. So the question is Syria under a legal obligation to do something, which means that if it doesn't do anything, it will be held liable for omission. In the Tehran hostage case of 1978, for example, the ICJ said that Iran, in that case, was responsible because it had an obligation to protect the embassy of the United States, and because it didn't fulfill that obligation, it was responsible for omission. Generally speaking, there are also other cases and other international texts which say that there is a kind of a general duty to prevent harm emanating from one's own state territory. That's the so-called no harm principle, neminem ledere, which comes also from environmental law, Trans-Delta case and so on. And in the ICJ Corfu Channel case, this judgment of 1949, the court somehow said that Albania is responsible for securing or taking away mines from the sea, based on a general duty to prevent harm from its own territory. And also the Friendly Relations Declaration, you know that's a declaration by the General Assembly, also mentions a duty to refrain from organizing, instigating, assisting, or participating in terrorist acts. So the Friendly Relations Declaration even mentions terrorist acts and says every state must refrain from assisting or participating. So you could say there is already some kind of duty here, but it doesn't really say that it's a duty to prevent terrorist acts. There are also other situations, particularly the situation of 9/11 concerning the Taliban in Afghanistan, where the Security Council has specifically spelled out obligations. For example, the Security Council had issued before 9/11, already in 1998, resolutions where it said that Afghanistan must eradicate the Taliban from its territory. I think that in that case, we have a clear obligation imposed on a state to do something, and if the state doesn't do it, then we can say the state is responsible through omission. But we do not have such a Security Council resolution in the case of Syria, actually. In international law, we moreover find duties specifically with regard to terrorist activities in various texts, hard and soft. But here also we must distinguish between different types of obligations, because if I say, up to now I only said the state must do something, but the question is what does the state have to do? We could distinguish at least two types in the anti-terrorism law: obligations to prevent and protect on the one hand, and obligations to apprehend and prosecute terrorists. So the first is more ex ante preventive, and the second type of obligations are more criminal law type activities. You could also ask the question whether the duties of a state are really general in the sense that a state must uphold an infrastructure which prevents incidents. Must a state uphold an overall capacity to prosecute terrorists? Or are we speaking of a specific duty in the individual case where there are some signs for a specific attack being planned? The broader duty is, of course, much more, you could say, more demanding from the state. So if we're speaking of omissions and responsibility for omissions, we are in the discourse and in the law as it stands, we don't really know which type of inactivity really triggers this responsibility for omission. In any case, I think that here, with regard to Syria, even if we might find some obligation of Syria to act, and as I said, I don't see any Security Council resolution, the omissions in themselves would have to reach the threshold of gravity to be counted as an armed attack. It's one thing to say that a state makes itself responsible through omission, and it's the other thing to say the state commits an armed attack through omission. And here I have a problem, or at least it's not, you would have to say that the omission is substantially really grave so as to be the equivalent to a large-scale armed attack, and I don't see that in the case of Syria. So it's difficult to argue that armed attacks can be committed through omission. So, next attempt to justify self-defense is to point to special rules on attribution to Syria in this case, which have emerged or which are emerging in the case law. And here we have these buzzwords which are around: specifically since 9/11, but already before in scholarship and in statements by politicians. I already mentioned some of the keywords: substantial involvement, harboring or safe haven. Aiding and abetting is also another keyword which can point to a concept which is also in the articles on state responsibility. But now the interesting and most problematic buzzword which the US launched, not for the first time, but relaunched in the letter to the Security Council in 2014, is the manifestly unwilling or unable standard. You know that this is a term also used in the ICC statute, Article 17, to trigger the jurisdiction of the ICC, but that's of course a different area of law. So, what about manifestly unwilling and manifestly unable or unwilling? As I said, the US rely on it. Turkey used the term in Australia. Only 3 states so far. I'm quite sure that no other state used the term. That's also interesting that the states really try to keep low profile and do not say, really, give any real legal justifications. I see problems with this term as a new standard. First of all, the question is, well, let's look at the handout. I put the problems on the handout. First of all, the United States may say that it's necessary that they can react, but necessity is not a freestanding basis of authorization in Article 51, but it's a limit. It says that first we have to have a trigger of self-defense, and then, if self-defense is allowed, it may only be necessary and not more. So necessity in itself is no basis at all. Second, unable or unwilling is a quite vague standard. When is a state below that threshold? When is it completely unable? When is it completely unwilling? From what point in time, how to decide whether a state is unwilling or unable? The main problem is, what I put under point 3, what is if the state is willing but unable? That is the situation of Syria. Syria is willing to combat IS but cannot. It seems to me that to attack or to cause damage in a state which is willing but only unable is not fair. At least one would have to say that the reacting states would have to first enable Syria, help Syria, cooperate with Syria to make Syria able. That would be normally the first thing to do, instead of bombing Syria, to help Syria to combat IS, if the goal is really only to combat IS. On the other side, you could also say that Syria in itself has an obligation to consent to activity which supports it against IS and to cooperate. A state which does not in itself have the capacities is not allowed to close itself down and not accept any support. That's, for example, established in the law of assistance in natural disasters, that a state which is struck by a natural disaster is unable to help its population. It is not allowed to arbitrarily withhold consent for other states to come in and help. But here in Syria, we have the situation that both sides do not want to do this cooperation. So the US insists on the fact that they do not cooperate with Assad. So I find the standard problematic, and it's therefore, to my mind, not a surprise that only 3 states so far have verbalized the standards. The question is then also how we can legally explain that the unwillingness and or inability leads to the allowance of military action, which clearly will inevitably affect population, territory, and infrastructure. One could say that Syrian sovereignty is a kind of forfeited, temporarily forfeited or suspended, or that there is an estoppel element here, that Syria would behave contradictorily if it does not allow military action. And then there is also another term discussed in scholarship, that there is in reality an ungoverned space, so that Syrian territorial integrity and sovereignty doesn't play or something like that. Okay, so now my next question is, I am showing you now that the law is in flux. I think that's what we can fairly say, that the law is not really clear. That for me, the strict reading of Article 51 self-defense is no longer valid, I think. That's quite, you can say that. If you look at practice of states tolerating the activity and also the scholarly debate. On the other hand, how could international law move at this point? We can't just say that scholars, through their writing, would be able to shift the law. That's not the case. We are not authorized to, we don't have any lawmaking power. So we would have to we can only contribute arguments to push the law indirectly in a certain direction. So technically, what would have to happen? First of all, we could say that maybe the interpretation of the UN Charter is changing now. And this can be explained as subsequent practice in terms of the Vienna Convention on the Law of Treaties, as a question of treaty interpretation. The other technical option would be the emergence of a new customary rule. A customary rule in parallel to Article 51. You know that Article 51 relies on the inherent right to self-defense, so there is an underlying customary rule. It could also move. I think it must move parallel to the treaty law. I think it doesn't have an independent life, but that's also debated. In any case, new custom would have to take time. On the other hand, we already have some time elapsed since 9/11, when this discussion basically started. So since 2001, we now have 15 years. It's already some time. But now, since 2014, things have moved much more quickly now. There is the buzzword of instant custom. Can custom emerge very quickly, instantaneously? I don't know. The other question is, how do we value and what to make out of the silence of the other states, which basically do not protest against what's happening? They just shut up. Is that acquiescence in the sense of international law? Acquiescence meaning that it is basically tacit approval? Acquiescence, or you can count silence as approval if other states or other actors have a legitimate expectation that a state protests. So silence in itself is neutral. It only signifies consent if protest is reasonably to be expected. I'll come to that later. Another question is, and problem is, that it is generally said, and has also been said by the International Court of Justice, that the prohibition on the use of force is jus cogens, a peremptory norm, and it is clear that the modification, the evolution of a peremptory norm of international law is more difficult than the evolution of a normal rule of customary law. So we would need a particularly strong practice and legal opinion, which is then in itself peremptory, to be able to shift that. Again, I have no clear answers. I'm just speaking about the possible technical venues, how to explain a change of the law, but I don't see that these things are really happening. Final point, and I come to my conclusion because that's no longer self-defense. We have the additional complication that we have a UN Security Council resolution adopted on 20th November last year, but it has some special features. First of all, it doesn't mention Chapter 7, which is normally the basis for coercive measures. Second, it has a soft language. It only calls upon the states to take all necessary measures on the territory under the control of ISIL. It does not authorize the member states. And the third point is, it makes a reference to international law. It says it calls upon member states that have the capacity to do so to take all necessary measures in compliance with international law, in particular with the United Nations Charter. So we here have a reference to maybe the law of self-defense. So the Security Council resolution itself doesn't seem to be a freestanding legal basis. It only points to self-defense. It resembles more the resolutions which have been adopted directly after 9/11, 2001, specifically Resolution 1368, which also only mentioned the right to self-defense, and even only in its preamble, it recognized the right to self-defense. I do not interpret those resolutions of 2011 as saying that the strikes in Afghanistan were covered by self-defense. And the same ambiguity is at work here with this resolution. No state has so far clearly said that this resolution in itself is the legal basis. The German Foreign Office came up with a very creative solution and names as a legal basis for the operation Article 51 in conjunction with the Security Council resolution, which is novel. Germans like conjunction. So the government came up with this combination solution. In the session of the Security Council, in the course of which this resolution was adopted, the states which were present in this session share the ambiguity of the resolution. They express support for the resolution and they stress the importance of an effective fight against IS, but they do not explicitly at no point say that the resolution itself is the legal basis. So the resolution, as you know, was of course on purpose adopted in this ambiguous language, because otherwise the vote of China and Russia as permanent members of the Security Council would not have been gained. So only through this ambiguity the resolution could be adopted at all. The other possible justifications, which I only mention to you, which I also mentioned on the handout, and we might come back to that, is of course the justification of invitation as a special form of consent. And you know that Syria only so far invited Russia, and Russia has therefore, and this is perverse, I think, the best legal basis for acting in Syria, namely the invitation by Assad. The only thing one could question whether Assad is entitled to extend an invitation. And you know that in the situation of a civil war, there has been a tendency in the 1980s to say that when there is a full-fledged civil war, the principle of self-determination leads to the forfeiture or non-possibility for a government to invite foreign help to combat a part of its people, which also reclaims self-defense. But I think that this theory is kind of, at least after Ukraine, kind of no longer really valid. So I think that Assad, unfortunately, I must say, from a moral perspective, international law does not give us a clear rule which says that Assad is not allowed to invite Russia. The massive violations of human rights, the war crimes and so on, have not, under the law as it stands, I think, led to a forfeiture of his right to invite. So the conclusion is open under point A. The question whether a normative shift has occurred since 9/11 and again since 2014, a shift which is just now happening, is for me open. First of all, only a few states explicitly invoke self-defense. Second, the reactive statements by the non-participating states are extremely vague and they rarely make legality claims. Third, some states, the bad states, have protested and objected against the military action, namely Russia, Ecuador, Iran, Argentina. China has said something vague, that it insists on non-interference, but didn't say anything specifically. And fourth, and that's maybe a point to be worth discussing, I would argue that the silence of all other 183 states or so is no acquiescence, because they are under no obligation to protest, because there is nothing to protest against. No clear claims have been made. My advice or my personal conviction about the role, my role as an academic concerning the law, is that as an academic it's our job to try to find a fair solution which would have to weigh the interests of the victim states versus the harboring state. And there is a tension there. We want effective protection against attack, like in France, for example, but on the other hand, allowing self-defense against non-state actors seems to be a recipe for escalation and abuse. See Turkey. I would insist as an academic on the role and responsibility of the Security Council. The Security Council can, of course, diagnose a threat to the peace and act against terrorism if no P5 vetoes such a resolution. There is a responsibility not to veto, I would say, but that's, of course, I mean, that's an academic statement. I don't think that China and Russia are listening to it. So our job as academics would be to advise governments to protest, even if I said the claims are so muddled that maybe there's no need to protest, but it would be a clear, it would still help developing and pushing the law in a direction, or not to protest, depending on your opinion, or at least to counsel governments to issue clear statements in order to clarify the law, which is currently in a situation of confusion and insecurity. Thank you.
Thank you very much, Professor Peters. Before I open the floor for questions, just two short reactions or two short remarks. First of all, you see that things which seem to be very easy on the political or moral plan are actually quite difficult in legal terms, because you see that there is no clear legal justification for the involvement against the Islamic State, though we would think that this is obviously natural, that we have the right to fight against such an enemy. And second, you see the beauty of the continental approach to international law and the structure of the analysis. That's something we should try to defend against the common law lawyers, which I think which have a different tradition, more pragmatic one. Now I would like to open the floor for discussion. Please, we have about 20 minutes left, so questions rather than long comments are welcome.
You can also collect and...
yeah, we can also collect a couple of them, and please introduce yourself, briefly mentioning your name and the institution you come from. So the floor is open for questions. It's always the challenge to have the first one. Petro.
Minister of Defense, Czech Republic. Thank you very much for your presentation. I really enjoyed. I actually have kind of difficult to understand the point that you made at the very last, that you said allowing self-defense against non-state actors leads to escalation of the problem, and you mentioned Turkey as an example. Their fight with PKK. But actually, Turkey is allowed to use force against PKK. This is not a problem of UN Charter or a problem of self-defense. Could you maybe more elaborate in this aspect? Because I don't see exactly how these two problems mesh together.
Okay.
Thank you very much.
Thank you. Another question? Let's collect a couple of them. Then, if I may, I will ask a question. It's quite interesting that in this debate about the Islamic State, we only see the traditional arguments that mean self-defense, individual or collective, intervention by invitation, and then the UN Security Council, which seems to indicate that the states have become more cautious or more conservative than in the past. Because, for instance, during the war in Afghanistan or the war in Iraq, we saw humanitarian intervention, preemptive self-defense. So, what has become of these arguments? Are they dead, or why haven't they been raised? And I think humanitarian intervention would be a good candidate.
Yes.
Still no third question? Then please.
Okay, thank you very much. Yeah, you said that Turkey is allowed to fight PKK in its own territory. You are right that Article 2.4 of the UN Charter, the prohibition on the use of force, does not apply within one state, only between states. But if there are agreements like armistices and other peace treaties or quasi-peace treaties, which I don't know exactly which exist, then the parties normally bind themselves also to the use of force. So I'm sure that some kinds of at least soft memorandums exist in which Turkey and the PKK bind themselves or promise, stipulate that use of force must end and is not allowed. And then, of course, Turkey is bound, even when acting within its territory, by the uses of humanitarian law and non-international armed conflict, and of course by human rights law. You are right that technically these two areas are distinct areas of law, but I think that, of course, they all come into play, and once military action starts, there is a bigger risk that also this other body of law will be violated. That's just what I meant, but it's very important that you ask for this clarification. Second question, why are we so conservative? Why is nobody speaking of R2P? I personally regret that too a lot, that responsibility to protect is not really any longer discussed. And I remember still keenly in 2013, when the civil war fully broke out, that was not so long after Libya, where, as you know, the idea of responsibility to protect was applied for the first time against the state, Libya. And the responsibility to protect is, you could say, a different way of speaking of humanitarian intervention. It shifts the focus to the victims and says that the victims have an entitlement, a right to be helped, and that we're not speaking from the perspective of the intervener state, which might claim a right to humanitarian intervention. But directly after Libya, China and Russia, which had abstained in the case of Libya, were really annoyed that the Libyan activity went on to a regime change and claimed that R2P had been grossly abused. I'm not so convinced. I think that the civilian population had to be protected effectively, and you could do that only by getting rid of Gaddafi. But you could also say they would have had to go against the opposition, which they didn't. And in any case, we see that Libya is a big mess now. So R2P doesn't seem to have, the humanitarian / R2P wasn't successful. And in Syria, I really remember that in 2013, from the beginning on, it was said that the situation is extremely messy, and R2P, as humanitarian intervention, requires that we make an assessment whether the prospects with a military intervention would make things better. Of course, this is always a speculation, and also ex post, we will never be able to say whether Libya would now be better without any intervention. Looks like it, but we will never be able to know. So in Syria seemed to be from the beginning on very complicated with the various groups. That from the beginning on, it was, many people said that the military intervention would probably not make the situation better. Nobody spoke of IS. I think the question could also be asked the other way around. Had the military action taken place, specifically after the chemical weapons had been used, most likely by the regime, Obama said this is a red line, but then the United Kingdom Parliament, and I find this really shocking in a way, in August 2013, 6 members of the British House of Commons voted against the proposal of the government to militarily intervene in Syria. And these 6 people decided, I think, very much about the fate of the region now. That's what we call democratic foreign policy. That 6 people decided that the UK wouldn't go, and then the US didn't go either. And then IS rose. I don't know. I can't say whether IS would have risen anyway or was already underway. I don't know that.
Thank you. So are there any other questions? There must be. That's not possible. Yes.
Tom Klobeček, local associate of the German Marshall Fund. I have just 2 very short factual comments. You just spoke about the start of the US-led campaign over Syria, but it actually started earlier on August the 8th, the kinetic phase, and August the 7th, the relief case in Iraq, a bit earlier.
Okay.
Second, regarding the...
But sorry, can I ask you a question back? Because that's of course very important. That was only in Iraq then?
Yeah, exactly.
Okay, and there we have of course a different... Iraq had already extended an invitation before, because the letter of 20 September only says, well, we repeat, we are grateful for help. So that was a clear basis on invitation, acting only on Iraq. But Iraq cannot ask for help outside the territory, so it's the next phase then. I mean, going to Syria is then clearly something different. And when did that start exactly? You know that?
You were actually right on September 23rd.
Okay.
That was correct.
Okay, good.
And I think you had another comment.
Second comment regarding the Khorasan group. Actually, you may have heard the name just about half a week before the air campaign started, because it got leaked in a congressional hearing. That's it's an artificial name, actually given by the US intelligence community to that particular group, because we don't know how the members of the group call themselves. And apart of that, I have also a very short question. I'm just wondering, I have really a very hard time seeing how you came to the conclusion that somehow Syria did something to prevent the rise of ISIS. It actually didn't.
And I also,
it can be manifested by facts on the ground that it has done either very little or
maybe even actively promoted it in order to
exactly.
combat the moderate opposition. Yes. No, I didn't mean to. I thought I didn't say it. I didn't say that Syria
actually
prevented or.
Actually, you did, and
also,
that's exactly why I'm asking.
Then that was a mistake. I only question the validity or the usefulness of the criterion unable or unwilling. So I said that that's how it looks like. Syria is willing now to combat IS, but now unable. That's the only thing I would say we can say with certainty.
So we have time for one or two last questions.
My name is Boriana, I'm from the University of Economics in Prague. Well, as per my research, there is still no precise term of terrorism. And as we know, obviously ICJ, and we have recently decision of the International Tribunal for former Yugoslavia about Karadzic, and my question is, when previous conflicts had happened, obviously ICJ established tribunals for intervening and eventually taking the decision of not done. The question now is there going to be tribunal of terrorism?
Okay.
I know it's very complicated.
There is already this Romanian initiative.
However, is ICJ has such an idea, and if you have any?
No, I don't. No, I doubt it, but I don't have any.
If I'm
Professor Bilkova knows more.
Yeah, actually there is an official initiative by Romania, and I think the second one is Spain. Yeah, to establish. They've already put forward the official suggestion and also the draft statute to establish an international tribunal for terrorism. But so far, I don't know. Maybe my colleagues from the Ministry of Foreign Affairs would know more. But I think the initiative was presented last year, but I don't think there has been any follow-up. So it's just it's on the table, and I think provided that obviously the definition of terrorism, as you yourself mentioned, is a tricky one, then I'm not sure there will be a political will to establish something like that. From the legal point of view, it's not that difficult to establish it, provided there is the political will, because it could be established either through the act of the Security Council or through an international treaty. It could be done. But I think for political reasons, there might be reasons not to do it. But that's my personal opinion. So,
okay, if I may, one more last question. I'm Kristina Nešpa from the Ministry of Foreign Affairs, International Department. I just wanted to maybe have one more clarification, or like you can make it as outcome of the presentation of your lecture. I was wondering if you were making like a clear difference between the individual self-defense and the collective. What relates, for example, now we have the attacks on France, in Belgium. Because your conclusion, as I understood it, was that the self-defense is not, sufficiently proved, or is not sufficient in this case. So, if you are making a distinction between the individual and collective, and how comes when we have these kind of effects?
Okay, you know that both is mentioned in Article 51. Collective self-defense, let's take Iraq as the starting point. Iraq felt threatened and asked others for help, so this is then collective self-defense in favor of Iraq. But of course this then presupposes that Iraq itself is allowed to rely on self-defense, because otherwise you could say the collective is kind of ancillary to the individual self-defense of Iraq. So the question whether Iraq is allowed to rely on self-defense against IS poses itself. So there we are then by that question. Now concerning France and Belgium, I think these are also fairly easy cases. They are further away in geographic terms, but they have been attacked. Well, Belgium, I think, is not, there is no clear authorship in Belgium, but in France, IS claimed authorship. It's clear that it's from IS, and IS also threatened new attacks. So in such a case, one problem is the gravity. If the attack would have been small, which was grave enough in France, but the question of the imminence of future attacks, because you know self-defense is not allowed as a punishment, but it must react to an ongoing or imminent attack. So in France, I think that the question whether the new attacks are imminent must be answered with a yes, because IS has threatened France. This was different, I would say, after 9/11, when you had the strikes to the World Trade Center, and then there was no announcement that there would be something new coming up. So I think that there the imminence of new attacks was not given. But here, concerning France, I would say yes. Belgium, I'm not so sure. And now if any other state, like let's say Germany, where nothing yet has happened, the question of imminence, preemptive, anticipatory strikes poses itself, which also Professor Bilkova asked. I didn't mention that because in the core issue now with IS it's not a problem, but for our states here, or Czech Republic, it is a problem, and I think that the reactions after 9/11 and also the reactions of the Bush US security strategy showed that the idea of preemptive strikes has not gained approval by other states. We need some objective, verifiable facts, not purely the statement of a foreign, of a security service or so, that we assume that there will be something coming, that we need some indications. And I don't think that, well, I can't say whether in other European states these indications would be considered to be strong enough. I don't see that for Germany, for example. No.
Thank you very much. Actually, this problematic is very interesting, and it has some implications that we probably do not foresee, because if there is no clear legal basis or no legal basis for the involvement of the US, the UK, France in Syria, that might mean that actually Syria is under the armed attack. Syria is the one which is attacked by these states, and Syria has the right to self-defense, and Syria could invite its friends, such as Russia, to help it strike back against the US, against Germany, against France, and that's something that we obviously wouldn't like to see to happen, but something that we should consider as a legal option, hopefully only a legal one. Okay. So we've reached exactly, that shows that we have people from Central Europe here, Germany and the Czech Republic, which means that we are exactly on time. It's 4:15. That's the end of this first part of today's event. Please join me, first of all, once again, in thanking Professor Peters for having come to Prague and having shared with us her ideas on the use of force against the Islamic State. Many thanks, Professor Peters. It has been really a pleasure.